Good afternoon, everybody. My name is Joey Barnett. I am a partner at WR Immigration. Thank you so very much for joining us today with our May 2023 Chatting with Charlie. I'm joined by Mr. Charlie Oppenheim. Charlie, great to see you. Hope you had a wonderful Memorial Day holiday.
Yes. Hope everybody else did too.
And if you guys have been listening to our past webinars, which are all on YouTube, you guys should go to YouTube and click in WR Immigration, Chatting with Charlie. You'll know that he worked for the Department of State for decades, and he used to write the Visa Bulletin, which comes out every month, I think for 23 years. And because of that, he's got some great expertise and experience with the annual numerically controlled visa numbers, which is what EB and employment-based and family-based, which is FB, and how folks get into the United States with immigrant visas. So we are very, very lucky and pleased to have Charlie with us. And today, the focus of our talk is about the EB-5, Immigrant Investor Visa. And I see we have people trickling in, so we're going to just go over some general stuff first, as we always do. Again, my name's Joey Barnett. I practice out of the Los Angeles office, and I'm here with Charlie, who is in our government relations group, and he's the director of our visa consulting. And like I said before, his expertise is unmatched, and I am honored to have him join and to be on this Chatting with Charlie with him. Again, this isn't legal advice. It's just for information purposes only. Every immigrant's circumstances are different, and there is no black and white answer for many things. So I ask that you please schedule a consultation with one of our experienced attorneys. We have a great EB-5 team at our office, and we have filed over 3,000, probably close to 4,000 of these I-526 cases on behalf of immigrant investors, and we've seen it all. And we are really on the cutting edge of EB-5. I was listed a top 25 EB-5 attorney. I'm on the AILA EB-5 committee. I'm on the IIUSA, which is the big regional center, not-for-profit trade association group, on their editorial committee. I sort of eat, sleep, and breathe EB-5. And so when there are issues that come up, we know about them. And part of this webinar here is to tell you what we know, so that you guys can make an informed decision when making your EB-5 investment. You know, EB-5 is a long-term process, and it's a lot of money, and you need to have a good understanding of the process, of the requirements, and some of the gray areas of the law and what we don't know. And so part of this webinar is explaining what exactly we know and what we don't know. WR Immigration, as you see on the slide here, is a top-rated immigration law firm. We're considered one of the best immigration firms in the United States. I joined this firm back in 2016 because of their reputation, and we are led by Bernard Wolfstorff, who is the former past president of the National AILA, American Immigration Lawyer Association. I think it's over 18,000 immigration attorneys. And right now, the future president, Farshad, is also a partner at our firm. And so we are very much at the very top of the line when it comes to legal representation. We've also developed some great technology called Rapid. We've built this in-house. We've won awards for it. It really simplifies the way that we practice immigration law. It allows everyone to complete things online, upload documents securely. Our EB-5 clients have found it very easy to use, and that's how we process cases. So let's jump right into it. The new EB-5 law, it's the EB-5 Reform and Integrity Act of 2022. It's been in existence now for a year, and EB-5 has blossomed. We filed more cases in the past year than we had in the 3 previous years because of COVID, because of price increases and uncertainty surrounding EB-5. But now we have a relatively long-term stable EB-5 program, and immigrant investors who are interested in EB-5 are taking advantage of that at very high numbers. There are really 3 big requirements for the initial process of the EB-5, which is the filing of the I-526E. You have to show that you have invested or are actively in the process of investing the minimum investment amount. That minimum investment amount is $800,000 if you invest in a project that's located in a rural area or a high unemployment area or in an infrastructure project. Otherwise, it's $1,050,000. Most regional centers that are offering EB-5 projects are sponsoring projects that are located at that lower investment amount so that you can get the same immigration benefit at a lower cost. So that's requirement number 1. You also have to demonstrate that the money that you've invested was lawfully obtained and lawfully transferred to the United States. And you work with Immigration Counsel to prepare a legal brief, and we compile and document and organize all of the information and documents that demonstrate how those funds were earned. And the US government really acts like a forensic accountant. They want to see tax returns. They want to see bank statements. They want to see employment contracts. Every investor has a different set of circumstances of how they earn funds. And we provide a personalized, detailed checklist of documents that they work to compile, and we review and we go back and forth. And that's a big part of our job as EB-5 attorneys, is making sure that we can file an approvable case. And we could do a whole webinar on lawful source of funds, and we probably should, because there are so many different iterations to it. But just some general thoughts on it is it can be more than one source. It can be gifted funds from parents. Money can be lent, and it doesn't need to be secured by any collateral. And so there are a lot of different options out there for folks, and that's something that we do to strategize to make sure that it provides the most sense for the investor and the investor's family, as well as so that we can file an approvable case with the documentation, because USCIS really does pick on this. And of course, EB-5 is a job creation program with an immigration benefit. And so you have to demonstrate how the jobs are going to be created, and you normally submit a business plan showing how those jobs are going to be created. And the real benefit of going through a regional center is you are able to count jobs that are created indirectly or through indirect or induced jobs. And many EB-5 projects are real estate based, because as long as the construction is built, the jobs are created. And they work with economists and use economic multipliers that show how many jobs are created based on the geographic location of the project, the industry category of the project, and you're able to mitigate the investment risk and the immigration risk, I should say, when you go through a regional center, because you're able to count these additional jobs that are created indirectly. One of the big changes to the EB-5 law is that there are these reserved visa set-asides. And not only are you able to qualify for that lower investment amount, but you're also able to get in these separate visa lines, which have been a huge boom, in particular for those who are in the United States. And they reserve a certain number of the visas that are allocated every year to these types of investments. And so they say 20% of all EB-5 visas that are allocated go to rural projects, 10% for high unemployment, 2% for infrastructure. And in the June 2023 Visa Bulletin, they all list current. We're going to show you that in just a little bit. And my question to you, Charlie, my first question to you is, how many of these visas can be made available to EB-5 investors in 2023?
For the rural area, it's approximately 6,800, about 3,400 for the high unemployment, and about 675 for the 2% infrastructure category. So a significant amount of numbers are being made available for potential use.
And this is one thing that, I was at the IIUSA conference last week in San Diego. IIUSA is the big EB-5 trade association. And this was something that I thought a lot of people didn't have a great handle on, is because there's a big difference between having visas that are available for use and then actually having them allocated to immigrant investors. And can you, Charlie, just maybe explain the difference between those two concepts?
Yes, so there is the overall annual limit, and then based on the amount of applicants who have approved petitions in any one of these categories and have submitted all the required documentation, then the visa office or U.S. Immigration Service would schedule the applicants for a potential interview for final action on their case. Unfortunately, I do not believe that any of these numbers will be utilized this fiscal year for the simple reason I don't believe Immigration Service has approved any petitions or that have approved enough that applicants can proceed with supplying the documents. So although there are potential numbers available, I think that they will all go unused in this category this year, as they went unused the numbers that were available in each of these categories during fiscal 2022.
And we're going to get into that a little bit, and that is nitty gritty, but I think it's important for folks who are listening to really understand that there is a little bit of government bureaucratic inertia. That was a term that I heard that I really like, and I'm going to keep repeating, between what's in the pipeline of pending cases at USCIS and what the Visa Bulletin can actually report. And Charlie, correct me if I'm wrong, when would and you sort of mentioned this previously, but when would a final action date be imposed? What information does the Department of State receive to impose a final action date?
The Department of State would know the overall annual limit in each of these categories. Then they would look at how many numbers in each of those categories have already been used through this point in the fiscal year. Then they would determine how many additional numbers could be used, and they would compare those two totals against the overall annual limit. If there's not enough demand to utilize all of the available numbers, the category is listed as current, as it has been through June. This means that there is enough numbers to make available to any applicant with an approved petition. If and when the demand exceeds the amount of numbers available, then the State Department would impose a final action date. But that should only happen once they know that the number used through that point in the year and the projected through the remainder of the fiscal year will exceed the limit. And because that's not going to happen this year, I believe that all of the three set aside categories will remain current throughout fiscal 2023.
And again, that's because of the long processing times by USCIS. And this is something that I tell every prospective investor, in particular, if you're from China or India or other countries where there are a lot of filings coming out of, just because it's current in the Visa Bulletin at the time of filing does not mean that there won't be a backlog or a final action date when your I-526E is approved in the future. That's what matters, not at the time of filing, but at the time of approval. And that seems to be something that is lost, and maybe it's just difficult to understand, but I really want to push that point forward, is that there likely are visa backlogs based on pending I-526E cases for Chinese nationals, for Indian nationals, and potentially for other countries as well, like South Korea, or where there are larger EB-5 markets. Now, the real benefit of the EB-5 law is this concurrent filing option. And we're going to get to what that means, but I want to talk just briefly about who can benefit from EB-5. There are a lot of folks in the United States who can file an adjustment of status because the Visa Bulletin is current at the same time that they file their EB-5 case. And in particular, for folks who are in the United States on H-1B or maybe F-1 OPT, and they're looking at other green card options, employment-based options, and they're looking at those lines and they're saying, look, I can't wait this long, and they're looking at EB-5 as a contingency plan. And we are seeing a huge, huge demand for that here in the United States. One thing that I get asked all the time is, well, can I come in on a visitor visa and then do a adjustment of status? And, this is a very, very tricky issue. Every investor has different circumstances, but and you should talk with a qualified immigration attorney to analyze this. But you can't come in using a visitor visa with an intent to file an adjustment of status. That's a big no-no. And the problem is that you can file it, and you can even get potentially your interim benefits, which we'll talk about, the work authorization and the ability to travel. But later on, there could be visa fraud findings, and that could permanently bar you from being in the United States in the future. And so there are serious consequences and risks involved with this option that you need to speak with your immigration attorney on. Some regional centers are out there and they're advertising, hey, come on in, file your case on day 2 after entry. And I don't know why they're advising that. Well, they'll say, well, we're not immigration attorneys. You should talk to your immigration attorney about that. They're interested in getting your investment funds. My goal as the immigration attorney is making sure that you get your green card, right? And so there is a little bit of a disconnect between what is being said and what is actually happening in reality, and some of the risks. And there are these rules that USCIS sets up, the 30, 60-day rule. The Department of State has its own 90-day rule. And my thought is it's best to be conservative here. And really, again, you cannot enter the United States with an intent to file an adjustment of status when you enter on a visitor visa. It's just a big no-no. All right, so the adjustment of status rules. Previously, before the EB-5 Reform Act, one had to wait for your I-526 to be approved in order to file an adjustment of status. The EB-5 Reform and Integrity Act removed that wait period of time. And now, if you're lawfully admitted into the United States, you can file your adjustment of status at the same time that you file your I-526E. And you're able to get a work authorization that's coming in around 4 to 6 months. You're able to get advanced parole that's coming in around 12 to 16 months or so. And you are able to remain in the United States even if your non-immigrant visa status expires because you filed the adjustment of status during the time in which you were here lawfully. And so this is absolutely huge. We are having folks get work authorization even before their EB-5 case is approved. And even if there is retrogression in the future, well, you still have your adjustment of status pending, and you're still able to continue to be here lawfully, and you're able to use your work authorization to work, and you can extend those indefinitely until your adjustment is adjudicated. Another big change is there's this provision in the Immigration and Nationality Act, INA 245K, which allows someone to file an adjustment of status even if you're out of status or if you've been working without permission for an aggregate of up to 180 days. And so for folks who are in the United States, maybe they've been let go on an H-1B And generally they have 60 days of grace period after being terminated by their employer. Well, under this INA 245K, you have a little bit more wiggle room that you can remain in the United States and file your EB-5 case and remain here and get your green card despite being out of status for a limited period of time. And so, a lot of people who are looking at partial filing, partial investments at filing, like I said at the beginning, you can demonstrate at the time of filing that you have invested the minimum investment amount, or you're actively in the process of investing the minimum investment amount. And so some folks are filing with just a partial investment and then completing the investment balance within 4 months, 6 months, 12 months. And we interfile then with the rest of the documents showing the money has been invested. But that way they're using the money that is liquid now and getting that earlier priority date, which, as we're going to talk about in just a moment, will allow you to speed up the amount of time that you will be waiting in the visa. All right, so this here is the Visa Bulletin from June 2023. It's chart A, the final action dates. And Charlie, maybe you can talk just a little bit about these new rows on the bottom that were created and what we're seeing in the unreserved visa category as well.
Okay. I'll start out with the 3 new set-asides: the rural, high unemployment, and the infrastructure. As mentioned earlier, that you will see a C listed. The C represents the fact that the category is current, meaning there are numbers immediately available for any EB-5 applicant with an approved petition in these categories for the month of June. It's always, as Joey mentioned earlier, it's always important. It is the final action dates that are being applied in the month your case can be scheduled, not the month in which you originally filed. But again, I believe these will stay current throughout this fiscal year and well into the fiscal 2024. With the unreserved categories, for all countries except China and India, the category is current. For China, a September 8th of 2015 date is imposed, meaning Chinese unreserved applicants who filed prior to September 15th could potentially be scheduled for final action on their case. My hope is that this date will advance to at least November 1st of 2015 for July or August. And then the India date has retrogressed to April 1st of 2017. This is effectively meaning that the India unreserved 5th preference category is basically unavailable. The reason I say that is Indian unreserved applicants started filing in significant numbers during fiscal year 2017. So therefore, most of those applicants should have been processed previously, and the State Department has imposed this date because basically after the month of June, they believe that the annual limit will have been reached for India.
So when you look at China mainland born and India, you see that there are backlogs for every employment-based category except for these set-asides. And that is why many folks in the United States are looking at EB-5 as a contingency plan, as a plan B, because they see the wait times and how slowly these dates are advancing in the EB-2 and the EB-3 categories. And so my question to you, Charlie, is let's say there was an Indian national in the United States with a EB-2 priority date of, let's just say 2017. Do you think that if they were to do an EB-5 set-aside type investment, that they'd be more likely to get a green card faster through that than if they were just waiting for their EB-2 to become current?
I think you're correct. The reason being, the annual limits for the employment second and third preference for fiscal 2024 and beyond for both China and India are going to be greatly reduced from what they have in the past 3 fiscal years. Therefore, I do not think there's going to be significant movements in the India and China dates. And therefore, somebody that's filing in the 5th preference at this point would be in very good shape. And it is also important to mention that if you are lucky enough, say that you had an India or China second preference petition already filed, if you are also able to file an employment 5th preference petition, then whichever date becomes available first, you would get. So you're kind of doubling your chances if you have the resources to apply in one of these new categories.
Yeah, that's a great point. Just because you're in EB2, EB3, that doesn't preclude you from doing EB-5. You're pretty much, these are all different lines to get the green card, and you can be in multiple lines, I think is what you're saying.
Yes, you can be in any preference category in which you're entitled to status. You can file in 1, 2, 3, 4. And it's to your advantage to file in as many as you're eligible to apply in to increase your chances.
Exactly. So someone who's on an H-1B and their spouse is on H-4 with an EAD, they both are able to file an adjustment of status if they invest in one of these set-asides right now. They both are able to file for the interim benefits and get that work authorization and the ability to travel once they have that advanced parole document. And so it's for the investor, it's for the investor's spouse, and any unmarried children under the age of 21. So everyone would be filing their own adjustment of status application based on the primary investor's I-526E, the EB-5 petition. Okay. Let's go to the next slide here. All right, so this slide talks about visa issuance in 2023, what is actually happening. And all of these visas relate to the unreserved visas, because as we mentioned before, the reserved visas, there's no demand for them at this point because the I-526Es haven't been approved. These relate to the unreserved visa category. And on the far right column, you can see how many visas have been issued through only the Department of State in the first 6 months of fiscal year 2023. So that's from October 1st, 2022, all the way through April of 2023. And let's first talk about India. Charlie, can you explain where that 666 number comes from and why this 588 number is impacting the retrogression that we saw in the June Visa Bulletin?
Yes, there are per country limits of 7% are applied to each of the visa categories. So India employment 5th preference is entitled to a maximum of 7% of the overall worldwide limit or EB-5 limit, and that results in a 666 limit. So far, as you indicated, through the first 6 months of the year, 588 numbers have been used, meaning there's only about another 80 numbers which could be used during May and June. And therefore, that is why they've retrogressed and the final action date for India. And I would, one comment on this is you see that through the first 6 months of the year, despite the high annual limit, only 3,082 numbers have been utilized. A certain amount of numbers have been used by the Immigration Service for adjustment of statuses within the U.S. But even so, this is a very, I would categorize as a disappointing total number use given the annual limit and how many have been used in the first 6 months of the year.
And what we saw in fiscal year 2022 was that I think it was around over a third of the EB-5 numbers that were issued from the consulate came in the last month in September of 2022. And so I'm looking at these numbers here and I'm expecting there to be something similar in fiscal year 2023.
That
Would
would
you?
be the hope. Uh,
Right, right.
the one unfortunate thing is that although there may be more now with this concurrent filing and everything else, it is possible that there may be more use within the US. But primarily the overseas number use, the summertime typically is not a peak time. And I believe that's part of the reason so many were used at the end of last year. There was a quote public outcry on the lack of number use earlier, and there was a concerted effort to maximize number use at the end of the year. But that is sometimes difficult for foreign service posts to do with overseas processing.
Right. And can you explain a little bit more why, um, at this point, China has gotten most of the EB-5 visas that were issued in this fiscal year, and that's been historically consistent with
Yeah,
what's happened in the past. But can you explain how that works with the per country cap and the otherwise unused visas?
right. So as mentioned, there is a per country limit, and the State Department may realize they'll estimate that, okay, India is going to use all of the 666 numbers available to them. Vietnam, they may say they believe that they will use all 666 numbers. Then they'll determine how many numbers will all the other countries other than China use, and they'll subtract those three figures from the overall figure. And if there's going to be otherwise unused numbers, then they can be made available for China. So for example, if the annual limit were 10,000 numbers, and just to make it easy math, they think that Vietnam and India will each use their limit. They will subtract that total from the limit, and then again subtract. They may estimate that the rest of the world will use 3,000 numbers, and then the remaining balance that would be quote otherwise unused can be made available to China. And that is what is happening now, and that has happened in every year of the EB-5 program where there have been otherwise unused numbers. They have gone to China because such unused numbers are made available strictly in priority date order without regard to the foreign state. And the Chinese applicants always have the earliest petition filing dates.
Thank you. Oh, and I should have mentioned at the top of this that if you guys have questions, feel free to shoot questions. We'll try to answer them. And please still continue to do so. We can answer them at the end of the presentation. And I also have to do a shout out here to IIUSA for giving me this slide that they compiled. Lee at IIUSA and Suzanne from Lucid Blog, who's a business plan writer and really keeper of all things EB-5 data. I know they put a lot of work into their PowerPoint. And so thank you for letting me take your work and discuss it. It was a really great PowerPoint and panel that you guys put on last week in San Diego. So thank you very much. All right, let's move on to the next. This has to do with reserve visas. And one of the items which we were a bit confused about in the language of the EB-5 Reform and Integrity Act related to the carryover. And so what the law says is if these reserve visas are unused, then they can carry over to the next fiscal year. And if they are unused in that subsequent fiscal year, well, then they can be made available to the reserve visas. And we asked this question to the Department of State through the American Immigration Lawyer Association. Well, when do these unused reserve visa numbers actually get used? And their response is at the bottom, is that at the end of fiscal year 2023, so in September of 2023, Any remaining unused visas from the fiscal year 2022 will carry over to the unreserved category in 2024. And so this means that those 6,396 visa numbers that weren't used last year, they're probably not going to be used this year because of poor USCIS processing. And we were hopeful that maybe they could be used to the unreserved visa category this year. But the Department of State has said, no, no, no. The law says, despite any policy that may, increase visa use, we have to wait one more fiscal year before they can be made available to the unreserved visa category. And all of that, what that is doing in theory is keeping these EB-5 backlogs where they are, as opposed to trying to reduce them. Charlie, I'd love to get your thoughts on this.
Yeah, I would have liked, and I have to say I'm not an attorney, and I assume what the State Department's lawyers have interpreted is correct, but I may have interpreted it to mean that if these 6,300 numbers were, if the State Department determined that they could not be used this fiscal year, then they could have been made available this year to the unreserved category instead of delaying such action for another year. The benefit of their interpretation is I don't believe that the unreserved processing would have been able to utilize these numbers this year, as we saw in the previous slide. So it may be a blessing that this interpretation has been made, and it will provide, I believe, and to be an all-time high for this new unreserved category. And hopefully the overseas processing, the Guangzhou is the primary processor of EB-5 numbers overseas. They may be still incurring some staffing and other issues impacting number use. Hopefully that will be resolved by fiscal 2024, allowing most of these numbers to be fully utilized next fiscal year.
So this chart here gets into the nitty-gritty of what we're discussing. And I wrote it assuming that none of the reserve visas are going to be used in fiscal year 2023, the same way that none of the reserve visas were used in fiscal year 2022. And so what this shows is how many unreserved visas will be available in fiscal year 2024. And what I want to say here is, a lot of people saying, oh, well, there's 6,396 unused visas, reserve visas from 2022. Now we can use them in 2023. But the fact of the matter, as we said at the top of the hour, was those visas aren't going to be used because there is no demand due to poor USCIS processing. And so all of those visas are going to end up being used by the unreserved visa category starting in 2024. The same could be said for fiscal year 2023. You can see that in this year, there are just under 2,800 reserve visas, rural reserve visas, just under 1,400 high unemployment reserve visas, and 280 infrastructure reserve visas. Those will carry over to the reserved in the in 2024. And then after that, in fiscal year 2025, they'll go to the unreserved. And so this huge bumper crop of additional visas that we have, because the employment-based visa limit for the year has been so high in recent years due to the unused family-based rollover, the benefit of that is being lost due to poor USCIS processing. And that's really the main point that I'm trying to get across in today's webinar, is that Congress's intent doesn't seem to be implemented because of USCIS processing times. And it's a shame because they have reduced the number of visas that are available to the unreserved category in the short term and not allowing the visa backlogs to be reduced now. Instead, they're pushing that out to the future. Of course, what Charlie was saying earlier is that, well, it doesn't seem like the consular capacity has the ability to issue these additional visa numbers, to allocate these visa numbers for use. And so maybe this actually is a blessing in disguise to push it out in the future so that consular capacity can get better and more visas can be issued then. Charlie, any thoughts as you look at this graph here?
No, it is it is going to provide a large amount of potentially available numbers in the unreserved category next year. The reserved categories will also have large totals. One thing that I would advise any applicant who has an approved petition, when information is requested, you need to process your case in as expeditiously as possible, submitting any requested and required documentation, because if you are at the front of the line, you want to make use of that opportunity as quickly as possible and not intentionally delay action. We used to see that when I was chief in China. Many times the Chinese applicants who were eligible for interview during the first 5 to 7 months of the fiscal year would reschedule their appointments for use during the summer because they wanted to do it during the summer vacation time. So they delayed action, and that sometimes impacted visa availability. They found that by having done so, their number was not available and their case could not be processed. So I always advise people, if at all possible, process your case as quickly as possible and do not reschedule and face potential delays in the future.
Yeah, I
And
can't.
that would count for any visa category, whether it's employment 1st through 5th, family 1st through 4th. Take advantage of your scheduled appointment in that month. And if by any chance you are refused, make every effort to overcome that refusal during the original month of interview.
And so, Charlie, I'm just going to go back to the visa bulletin. You know, if you were an Indian national on H-1B and you see this visa bulletin here, what would be your course of and you have the ability to do an 800K investment for EB-5? I mean, what would what would be your decision-making process look like?
Yeah, I think whether I was Indian, Chinese, from any country, I would think that the rural reserve set aside, if I had the money and was planning on doing it, I would file in that category. I would do as quickly as possible because, again, it is always important to be at or near the front of any line that may develop in the future. And by filing in the upcoming months, even if there were eventual final action date imposed, I think the resulting processing time before you would get final action would be within a reasonable amount of time. Whereas somebody that had filed in India second back in 2012, they would not feel that their case is going to be processed in a reasonable amount of time.
Yeah, I agree. I mean, we don't really know how many cases have been filed at this point with USCIS and are sitting there. All we know was, I think back in March, they told us when they were refunding the biometric fees for existing I-526E cases that there were 980 of those filed, but we don't know what country they're from. We don't know what visa category they're in. And so it's difficult for immigration attorneys and regional centers to advise clients on, well, hey, should I do rural or should I do high unemployment? You know, we don't have the data. And as soon as that data comes out, you know, you can expect if everyone has zigged, now everyone's going to start zagging, and those other visa category lines are going to get longer. And so you kind of have to go with what I think is just kind of like the math at this point. And there's just twice as many visa numbers in rural as there are for high unemployment. And that's all that we can really say. I mean, if personally, and again, this is just anecdotal, it's nothing that should you know, really influence your decision. But for folks in the United States, I would say it's about 60% for my filings have been in high unemployment versus 40% rural. That's what I'm seeing, at least. But I think we're going to start seeing more and more rural investments as people understand this a little bit better.
Yeah, it would be, as you say, it would be very beneficial if the Immigration Service would start publicizing information on the amount of filings by category and break it down by month of filing, and do so in a timely manner so that people could make more informed decisions, as you mentioned.
Thank you, Charlie. We have a question here for, it looks like, an existing India EB-5 investor who's in the unreserved visa category. So I'm going to go back to the June Visa Bulletin here. And he's asking, what does this mean for an Indian investor with a priority date of September 30th, 2019, whether the visa is available? And this is for someone who's out of the United States. And
Right.
the answer, go ahead.
In the unreserved category?
In the unreserved category.
Yeah, they are not eligible for scheduling. They will not be I can pretty much guarantee a visa number would not be available for them to be scheduled this fiscal year, because what State Department is saying in this bulletin is they only have enough numbers remaining available to schedule applicants that filed their petition and have an approved petition with a date prior to April 1st of 2017. My hope would be that in October, which is the first month of the new fiscal year, that they would return the India unreserved final action date to at least June 1st of 2018, which is the last date it was before retrogressing, and hopefully beyond. But for this applicant, I do not believe your case will be eligible until the late fall or early winter of fiscal 2024.
And then the other question he has is, will USCIS even process this I-526 petition based on the visa availability approach? And the visa availability approach looks at Chart B, which is separate from, and that's the date for final action, as opposed to final action dates here, which is Chart A. And to be honest, I don't remember off the top. Do you remember what the DFF is for India unreserved?
No, I don't, but I can say that it is likely to, I believe it would be in 2019 or so.
Yeah, I think it is. I'm not sure the actual date.
Yeah, so they in theory should continue to process any of the cases that were filed in the petition and continue to work on those, because the application filing dates indicate where the State Department, in consultation with immigration, believes the final action date will be 8 to 12 months in the future. Therefore, they should continue to process those petitions so that they'll be ready to go, in the 8 to 12 months in the future.
Yeah, I mean, I honestly don't know how much they actually follow the visa availability approach. I know they say they do, but we have data from FOIA requests and other ways of showing that they don't. And, from my own experience, they seem to be adjudicating cases, including those from India right now, that were filed in like June, July 2019 is where we're at.
And I just pulled up to confirm the dates for filing. And for India, the unreserved is December 8th of 2019.
Okay,
So,
perfect.
so anybody that had filed with the Immigration Service or with the the IPO office, if they have a petition with a priority date earlier than that, they should be continuing to process that so that the case is ready when and if a number becomes available.
Okay, so that's good. So that means that for someone who filed in September of 2019 in Indian National, they would still be eligible for processing based on the visa availability approach.
Yes, and there will be a higher limit where we mentioned earlier that there was under the per country limit of only 666 this year. Because of the higher unreserved limit next year, there'll be far more numbers available. So that will increase, that should increase both the China unreserved and India unreserved final action date movements.
Oh, that's a good point. That's a good point. So because those unused reserve visas from fiscal year 2022 will be made available to unreserved in fiscal year 2024, there's more supply of visas, which will allow the Department of State to push out those final action dates a little bit further.
Yeah.
Right. Okay. That's the only question I see that we have here. I want to thank you all for joining us today. Charlie, as always, I appreciate your time and expertise. And if you have any questions, please feel free to reach out. Let me pull up the final contact information. My email is jbarnett, my last name, @wolfstorf.com. Feel free to reach out. I'm happy to do a no-cost initial consultation for any EB-5 investor. And I hope I get the opportunity to help. Hope this was a useful amount for your time. And we thank you so much. So have a lovely day.